Good afternoon, everybody. For those of you who do not know me, I'm attorney Marjorie Brunelli. I'm located in Fort Lauderdale, Florida. Today I'm going to be talking about prenuptial agreements, the famous prenup, post-nuptial agreements, and cohabitation agreements. So what's the key difference between a prenup and a postnup? The prenup, obviously, it's done before you get married. The postnup, after you get married. The postnup also has additional execution requirements because it's more formal, because it's being done after you got married. So it has to be executed with the same formalities as a will. And it also, for the most part, is easier to invalidate than a prenuptial agreement. Obviously, that's the short explanation. If you need more explanation, more details, it's a case-by-case basis. You can always call the office. The number here is 954-474-7703. But it's also one of the reasons as why I recommend that my clients do a prenuptial agreement and take care of everything before they get married. Another key point that's very important is sometimes people will call and ask, okay, can I have a prenuptial agreement done in the next 2 days because I'm getting married by the end of this week? Well, not so fast, because there's already case law in Florida that invalidates prenuptial agreements that were done and executed less than 10 days before the date of the wedding or the marriage or whatever. So I do not recommend that something like this be done in a hurry. It's not the type of document that you want to execute in that way. You really need, I always recommend both parties to have their own attorneys, so there is no appearance of impropriety or duress or any other type of situation that could perhaps cause this agreement to be invalidated when one of the parties is not represented. It's not a requirement, but I always recommend. Everything that you can do to keep it safe and valid and enforceable is recommended. So as to property, why is a prenuptial agreement so important? A lot of people have misconceptions. They think, okay, if I keep my properties under my own name, or if I keep my salary, my wages, my income in a separate account, I'm not going to have a problem. That's not the case in Florida. Because once you get married, guess what? Everything that belongs to you belongs to the other person and vice versa. And that's not only for assets as well as for liabilities. So the prenup, if you want to divide property in a different form, for example, you want to keep all your prior property that you acquired before the marriage as only your property, you need a prenuptial agreement. Also, if you want to determine how future property is going to be divided, you can establish that in that same agreement. So it's a very important document, and I highly recommend it, particularly for people that are entering into their second or third marriage at a later age. Generally speaking, those people have already their life made. They have a lot of money in retirement accounts. And once you get married, half of that money belongs to your new spouse. So if you want to keep that as separate property, you need a prenuptial agreement. Another thing that's also very important, let's suppose that one of the parties has real estate property. They already purchased and paid for their property, and then you get married and your spouse moves in with you and it starts helping you with improvements to the home. If you have a mortgage, helping you pay mortgage payments, any sort of expense relating to that home. Even though you purchased that home prior to the marriage, now that your spouse is contributing, it could become marital property. Sometimes the whole property, sometimes part of that property. So that's yet another reason why the prenuptial agreement is so important. Also, if one or both of the parties owns a business, we can also list that, and we can explain, okay, what's going to happen once that business is sold, or once that business start being more profitable, how is that going to be divided? Is my spouse going to have any rights to this, or this is only mine because I created this business, so I'm the one that has the right to receive any profits or any losses from this business. And, you know, me, myself, and I alone, not anybody else. So that can also be included. Another issue that we see a lot, mostly for the famous people out there, rich and famous, in Florida, it's a no-fault estate. What does that mean? It means that even if you cheat on your spouse, that doesn't really affect your divorce proceedings, unless you took a significant portion of your assets and gave that to your, I don't want to use this word, but concubine. Or your, you know, affair, or your lover, whatever you want to call it. But anyway, so in that situation, obviously you would affect the divorce, but otherwise, no, it's a no-fault estate. So, you know, cheating is not really relevant with that particular exception. So what we see people doing is including fidelity clauses on the prenuptial agreement. And that way, if one of the spouses cheat, there will be consequences as to the division of property. And that can be designed whichever way the parties intend. It's case-by-case basis. Another thing that we can also include is a clause for attorney's fees. So if one of the parties decides to basically, how can I say this, contest the agreement, and that party loses the lawsuit that she or he filed contesting the validity of that agreement, then that party will be responsible for paying the other party's attorney's fees, and that's kind of a deterrent for that, you know, particular act. It's to keep people from doing that. You know, all of a sudden it's like, oh, I don't like this agreement years down the road. I don't like this. I don't know why I signed this. I'm going to try to invalidate it. So that clause acts as a deterrent to that particular situation. And I made a little list because it's a lot of information. So you're going to notice I keep looking at the computer. Also, we can include an expiration date to the agreement. Let's suppose that you decide, okay, I'm going to have this agreement in place and valid and enforceable for 15 years. If we stay married for longer than 15 years, so, you know, that's the expiration date for this agreement. It's no longer valid. So you can definitely do that as well. What else? Let's see. Another thing that's very important, if you create an agreement that completely leaves the other party totally destitute, you're gonna have an issue, because generally speaking, when you have a prenuptial agreement, both parties agree to waive alimony and all types of alimony. But if you do something in a way that after years of marriage, you have a certain lifestyle, and if you get divorced, the other partner, spouse, is left with nothing, that's against public policy. So even though the parties agree to waive alimony, if that's the situation, that party will be entitled to temporary alimony, because that is not the point of, you know, a marriage between the parties. You can simply live with somebody for 10, 15, 20, 30 years and then expect to walk away rich and leave somebody with nothing. That is not how the law works. Also, as to modification and amendments, you can do that. If, you know, 3-5 years down the road, you decide, okay, our situation has changed, let's modify certain clauses in the agreement. As long as you do it in writing and also signed by both parties, it's fine. You can definitely amend or modify it. That's not a problem. Other clauses that we can include as well are relating to pet ownership. You can include that on the agreement as well. The only thing that cannot be included is as to visitation for pets. Also, child support and time sharing for children cannot be included. That's a specific Florida law It's determined by the guidelines depending on the income of both parties, as well as the time that each party stays with the children. So it's a totally different situation, and that cannot be stipulated in a prenuptial agreement. However, one thing that sometimes is recommended is putting a simple clause, adding a simple clause where the parties show their intent as to the children in case of a divorce. So it's really just to show the court, okay, this is how the parties thought about the situation when they were happy and everything was going well and they were about to get married. That's what their intention was for the children in case of a divorce. So just really to show the intention of the parties, but not to stipulate time sharing or child support. Another thing that's also important is alimony. You can always stipulate what the alimony will be for your spouse or partner if you decide to get divorced. And generally speaking, we do it every few years. So, you know, you can always stipulate, okay, if we're married for 5 years, I'm gonna provide her or him with this amount of money for this amount of time. If it's 6 years, you know, something else, a higher amount, and so forth and so on. But there are also situations where they decide they're not gonna provide any alimony. So it's 0, as long as, you know, we remember the exception for temporary alimony. Also, if there are children from prior marriages, you can also include clauses for that. If they're living with the couple, we can definitely include something relating to college, to support, and things of that matter. That can also be included. Another issue that we see a lot is if one of the parties decides to pursue a graduate degree, such as a medical degree or a law degree. According to Florida law, the other person can be responsible for about half of the student loans. As we all know, it's like having another real estate property. It's very expensive to obtain a higher graduate degree in this country. So that can also be stipulated. You know, if one of the parties decides to go to medical or law school or dental school or whatever it is, that party can stipulate, okay, if it's my decision, I'll go and I'll be solely responsible for my student loans, and the other party is not gonna have any responsibility. Or they can stipulate in another way. They can say, okay, you know, as long as that the other side is enjoying the fruits of my labor, you know, can do a percentage. You know, maybe that party, in the case of a divorce, after a certain amount of years that I've graduated and I've been in practice, that party is going to be responsible for a certain percentage in accordance with the same percentage that she or he enjoyed the benefits of that profession. So there are different ways to do it. It definitely depends on, you know, how the parties want to do it. And again, if you need to ask me further questions, or you need to schedule a consultation, this is really something that a video on Instagram cannot cover. It generally takes me about an hour to go over all the topics, and you can call me. All my information is up on the bio, and my phone number here is 954-474-7703. And let's keep going. I have a few more notes here that I want to keep discussing. The other thing that's also very important that sometimes people don't realize, in Florida, when you have real estate property, you have passive appreciation and active appreciation. Active appreciation is when you pay the mortgage, you do improvements to the property, renovations, so you're doing something active that's gonna raise the value of that property. Passive appreciation is just really the market. You know, if the economy is doing well, the value of the property is going to increase. So we can definitely address that in the prenuptial agreement as well, if you want to keep that separate or not, because the law is different. I'm not going to go into details, but that's something that can also be included. Also, we can also address homestead rights. as well as what happens with property upon the death of one of the spouse or partners. We can also include something else that's very important, which is if one of the parties is having problems with addiction or substance abuse or gambling, excessive shopping, you can always include a clause that says, okay, if you don't get your act together, within the next 30 days and go to rehab or therapy or whatever the means is to resolve that situation, then we're going to file for divorce. So there are ways to address those things as well. So as you can see, prenuptial agreement is a very all-encompassing. There's another thing that I think is also very important that a lot of people don't realize, and it's relating to retirement accounts. That's how do I put it? It's coordinated or regulated by federal law, which is ERISA, E-R-I-S-A. That's the abbreviation for the act that regulates that. And that act, that law says that only spouses can waive the right to retirement accounts. Well, then what happens? When you're doing a prenuptial agreement, you're not a spouse, you're a fiancé, you're just engaged, you're not married yet. So a lot of people do not know this, but this is very, very important. That's why I always recommend don't go do a prenuptial agreement with someone that does not do family law and does not work with this type of agreement, because there are specific laws that you can set yourself for failure. Because what happens? You include a clause in your prenuptial agreement that says, okay, everybody is, giving up the rights to any retirement accounts from each other. Great. But you're still not married. So once you get married, if you don't execute an additional document confirming that clause from the prenuptial agreement, it's pretty much invalid. So there are dire consequences for doing something the wrong way. So be very mindful of that. It's not that, oh, you need to hire an attorney. It's not that. But when you have a lot of property, a lot of cash, a lot of retirement accounts, investments, sometimes you have children from prior marriages, you're receiving alimony, or you're the beneficiary of a trust, or you have inheritance coming to you. I mean, the situations are so many that I can think of. So it's very, very important. And, people sometimes say, oh my God, but that's horrifying. We're about to get married and you want me to sign this document. That's horrible. Like, we love each other. Okay, I think sometimes people need to put aside the emotional factor of getting married and be a little bit more rational, because when you're talking about a marriage, what is a marriage? It's a contract between the parties before the government. It is. There's, I know we grow up watching princess movies and fairy tales and this and that. Yeah, it's beautiful on TV, but in reality, when you're dealing with the contested litigated divorce, the picture is very, very different. I mean, I see this every day in my office where people are fighting over the spoon in the kitchen because they are so, all over the place with their emotions and anger that they just want to destroy the other person. So, there's a saying that, it says you don't really know someone until you actually have to get divorced. So, that's just unfortunately the way that I think sometimes you need to look at it, because I have a lot of cases of people that come into my office and unfortunately, they received the wrong advice. They were told, oh, you don't have children with this person, you don't need a prenuptial agreement. That is not the case. And then they're stuck with having to give, $500,000 out of their prior retirement account to someone that had nothing to do with acquiring those funds. So it's very sad to see, but it does happen. So that's the reason I did this video. I hope it's helpful. Quickly, just so I can talk a little bit about cohabitation agreements. I almost forgot. Cohabitation agreement is for people who are not looking to get married, but they want to live together and sometimes even buy real estate property together. So I recommend doing a cohabitation agreement. even though it's still considered illegal in Florida, before family court, it can be enforced in civil court as a contract. So if one of the parties breaches, you can bring the litigation in civil court. That type of contract can stipulate who's going to be paying for rent, groceries, utilities, and if there's real estate property that you purchase together, who is going to be responsible for the mortgages, insurance, anything relating to the property. And if you decide you no longer want to live together or be together, how all of that property is going to be divided. So that's another option as well. You don't necessarily need to get married. There are ways to do it and keep it formalized so that you don't have a problem once you decide that that person is not your person and you want to part ways. So that's it for today. I hope it was helpful. Feel free to reach out. Again, all my information is up in the bio. And have a great day. Bye.